amount for suspension and resignation with charges pending to zero. So the presumptive amounts in those instances would be zero. What our position is basically that the court should have discretion in those instances, in the instances where the presumptive amount is zero for suspensions or resignation with charges pending. The state bar court should have the ability and the discretion to make a recommendation for a higher amount, so that if the state bar court sees facts that they believe warrant sanctions in a higher amount, they can make that recommendation, again, laying out the grounds on which they're making that recommendation, so that when the Supreme Court then looks at it, the Supreme Court has a basis for exercising their statutory discretion to decide whether or not to impose sanctions, because the Supreme Court, under the statute, has to retain that discretion. The Supreme Court has that discretion. We can't take that away without a statutory amendment. So that's basically our position, that discretion should remain with the state bar court to impose sanctions above the presumptive minimum in cases where they believe it appropriate, so that there's a basis for the Supreme Court to then exercise their discretion.
And if I could just, I'll note that one of the examples given for an instance where either the state bar court or the Supreme Court would exercise that discretion was the lack of candor of the respondent. And one of those, or two of those examples, I believe, were significant insofar as it wasn't just not telling the truth, it was fabricating documents as evidence and submitting that, correct? So that, to me, makes a lot of sense. I'm assuming that's where this comes from.
Yeah, and in part that comes from it. I mean, we had provided those examples in connections with disciplinary costs, and they're in footnote 1 of the agenda item if you want to look at those. But yes, those were instances where the state bar court essentially found that the individuals at trial had lied and fabricated documents in connection with their defense. And if you have that and you have sufficiently egregious underlying misconduct, sanctions can be not punitive, but an appropriate part of an overall package of discipline that serves the non-punishment purposes of discipline, deterrence, general deterrence, and even to a certain extent rehabilitation, to the extent it tells someone, hey, you've got to pay for what you do, don't do it again, and restorative justice, because those funds, I believe, end up in the client security fund. Thank you. So that's our view, that there can be cases where sanctions can be an appropriate part. And we're not saying that should be the norm. The norm should be zero in the suspensions and the resignations with charges pending, but the state bar court should retain the discretion.
Thank you, George.
So we have at least one staff person here from State Bar Court. I just want to make sure they have the opportunity to share their views. I see Kathy. Go ahead.
Yeah, I'm happy to, although I think Suzanne did a very good job of laying out what our position was. I think essentially the court comes to this from the perspective of seeing sanctions as punitive and therefore, not consistent with the purpose of the discipline system, which is for public protection and rehabilitation. But absent support for the idea of eliminating sanctions, which would take a legislative action, the court does support the proposal that's before the board today, which would limit sanctions to cases of disbarment as a kind of clear way of saying this is only for the most egregious cases, because those will be cases where disbarment is sought.
Thank you, Ms. Scher. Any other? Trustee Tony.
It seems to me that disbarment is an extreme measure that is not taken lightly, and that is quite frankly, I believe from looking at previous reports, is pretty uncommon, okay? So that's my first comment. If you break the discipline system, you're supposed to be punished. I have no issue with punitive fees. I'm gonna give an analogy, and the analogy being the operating a motor vehicle, okay? The most extreme sanction is to, let's just say, just to stick with just the operating part, is revocation of your driver's license. That, that's the most extreme. But there's so many other infractions that everyday people are subject to. There's a speeding fine. There's a fine for driving in the diamond areas when you're not supposed to during the time of day, the commuter lanes, right? There's failing to stop at a red light. A whole bunch. Everybody knows them. Every single one of them comes with a monetary fine. Parking space, you don't put money in a meter, you get a parking ticket. And so I absolutely have no understanding of why there wouldn't be monetary penalties. I know that's punitive, but yes, penalties for infractions of that warrant discipline to be, decided upon that are short of disbarment.
Thank you for the commentary. Leah?
Well, I'm just going to suggest that perhaps when we bring this one back to the board for an actual vote, we just have two different versions of the rule. One that reflects the current staff proposal, which is supported by the State Bar Court, and one which reflects the paradigm that OCTC seeks. And I think we can move it forward that way.
Okay.
Okay.
Let's move on to expungement, please.
Great, thank you. So the board asked staff to develop a definition of expungement, and noting that there was not only an issue with expungement, but also removal from the website, and in trying to differentiate those two things, we chose to define expungement broadly, because otherwise it would seem redundant with the other recommendations. And so the definition that we proposed is that the disposition would be updated, the disposition of the discipline would be updated to expunged, and the discipline would be removed from the licensee's public discipline history, which is more extensive than removal from the website. It's from their entire public discipline history, meaning that essentially it would be deemed not to have occurred for most purposes. This also means that the discipline would not be available on the website, but as I said, it's broader than that. But it would also not be available upon written, telephone, or in-person requests. And the discipline could not be used in a subsequent disciplinary proceeding as an aggravating circumstance or as prior discipline pursuant to standards 1.5 or 1.8 of the standards for attorney sanctions for professional misconduct. The expunged records could also not be used by OCTC in any sort of pattern analysis or an attempt to identify any patterns of misconduct. The discipline, as I mentioned earlier, obviously would be also removed from the attorney's profile page on the State Bar website if it had not been earlier based on the removal from the website recommendation that we'll talk about in a moment. There is one limitation, as I mentioned, and that is eligibility for judgeship. The licensee would not be relieved of any duty to disclose that discipline for purposes of determining their eligibility for judgeship under the California Constitution. The State Bar would also need to maintain records in order to be responsive to those types of inquiries as well. I would note that there are a number of outstanding questions in relation to this, and I won't take up too much time on that particular issue here. They are in the agenda item, and I'm sure that there are some that we've missed, but there are some questions about whether we can do it, and if so, what that would look like. As far as the reason that this is here today, that is because we really need two things from the board. Number one is guidance as to the proposed definition of expungement. Should it be this broad, less broad, broader? And number two, direction as to the option to pursue. And that is, while staff initially envisioned this as continuing with a petition to the Supreme Court for expungement. When we met with stakeholders, that was not deemed satisfactory, and so we came up with another potential option, and that was that it would be automatic after specified criteria are met. And that criteria could include a period of time. It could include a limitation on the extent of discipline that would be subject to expungement, or some other criteria as well. So with that, I will turn it back.
Ray, please.
So I was involved in a lot of the discussions on expungement in this ad hoc committee. And what I had tried to bring to the table is more of an example of what happens in the criminal context. So with every defendant that has a conviction, for the most part, after a certain period of time, there is a petition they can file that they would get a mandatory expungement granted. So there are exceptions, like, for example, murder or rape, those kind of cases. But in general, a defendant in a criminal case has a right to a mandatory expungement of their conviction. And it is important for them in many aspects of their life in the future. If it's for job reasons, for housing, things like that. There is also, there's this thought in many of our communities, the idea of giving someone a second chance. And an attorney who commits misconduct, who is disciplined by the bar, and who has, and some time has passed to demonstrate that he has been rehabilitated or she has been rehabilitated. So we just thought that it would be appropriate for them to have a path to clear their record of sort for the mistake that they may have made and be able to move forward. Without that, it's very hard for an attorney to continue with their profession with this record of conviction per se. And it seems like a fair way to deal with changed behavior, someone who's accepted responsibility, and someone who really would like to move forward with their career and has done everything right. And so this whole issue about second chances and being able to clear the record and move on, that was what the Fairness Committee was really focused on. And I think we had a lot of really good discussions. There was a lot of debate about expungements and pathway forward. And I think the bar should consider moving forward on this issue. Thanks.
Sarah, please, and then Mark.
Yeah, I was also on this committee with Ray and actually Steve as well, where we sort of respectfully disagreed with each other around some of the timelines for it. But the other thing that it's important for the board to keep in mind is why there was an ad hoc commission on the discipline system. Why were we there? Well, we were there because of the Farkas report that identified really gross racial disparities in administration of the bar's discipline system. And in particular, that Black men were 4 times more likely than everybody else to be disbarred or suffer discipline. So in addition to the goal of rehabilitation that Ray just articulated, we also were very concerned with providing a path forward for some of these folks who had been tripped up in the prior regime and giving them a way to potentially get their law license back and practice law in the future if that's even feasible for them. So that was, a huge concern for me, was how to redress the inequities of the past, as well as providing a path forward for people who got their act together, didn't engage in any other misbehavior, accepted responsibility for their wrongs and could move forward. So I think that's an important backdrop to this particular conversation. Thanks.
Thank you, Sarah. Mark Broughton, please.
Thank you. In my neck of the woods, which again is criminal like Ray's, expungement is a term of art. And years ago, I think it was up until the mid-90s, someone could go and get their record expunged if they complied with all the things they were supposed to do, which meant and means wiped off the face of the earth so that nobody could ever see that they ever had a conviction. If they applied for a job, they could say, no, I've never been convicted with a few exceptions, that type of thing. Nowadays, since the internet and everything else, a person can make that motion, but the case is dismissed. It's not expunged. And so the record will show I was convicted and they withdrew their plea or whatever it was, and then the case is dismissed. And so theoretically, they can now say to the world that I don't have this conviction. Well, there's a bunch of problems with that nowadays when people go in and look and do searches and they find this out. So my question is because we use the term expungement for this, is the conviction, if you will, is that sort of a public record? In other words, does that go out to the world somewhere? And when we're talking expungement, are we talking wiped off the face of the earth, or are we just talking something similar to what happens in criminal law now?
It's a great question, and that was one of the things that we really struggled with in trying to address the board's resolution and request of us. You know, I also have a criminal background, and so I'm familiar with what you and Trustee Buenaventura were saying, right? You know, essentially the relief that's granted is not really an expungement. It's a relief under 1203.4 or a similar statute, which does exactly that, and that is only updates it to say that relief was granted, and it doesn't do anything else. And the only express statutory relief that's granted is the ability to not say when you are applying for a job to a private employer that you don't have a conviction. You can say that you don't have a conviction. You know, since 2018, when Ban the Box, or the Fair Chance Act, I guess, as it's otherwise known, was passed, I'm not even sure how much of a benefit that 1203 relief is, but it is routinely, as Trustee Buenaventura said, it is routinely granted. We'll talk about that more with the other proposal, but that's why we chose to sort of define it broadly, was because we thought that the direction of the board was to get a definition of expungement. Again, that's one of the reasons we're here, is to find out whether we are on the right path of a broad definition or not.
So it's really a dismissal. It isn't quite a true expungement.
Well, it would not be posted on it would no longer be posted on the profile page, and it would no longer be part of the public discipline history, even when requested in person or in writing or by telephone. That's one of the open questions that I alluded to earlier, would be whether OCTC and the State Bar Court would do anything with their records. I don't know that, I think the answer would be no. And so those records would remain, and so if somebody went to the State Bar Court website and did a docket search for the individual or the docket, that would probably come up. But again, I think that the theory behind it is that the outcome would be updated to expunged. But of course, the board is in control of where this wants to go.
That's my understanding of what the proposed definition is as well, that the record in State Bar Court would remain. So in other words, the record in State Bar Court and in our records would continue to show that there had been a finding of culpability, that discipline had been imposed, but that an expungement had been granted. For me, the question that I think the board should also address is whether that expungement should extend to OCTC accepting all of this, that we want to give people a second chance and that we want to give them the ability, if they've turned their lives around and not do anything different, to have that come off their record so that they don't have to deal with it. But if they do something else, in my view, OCTC should be able to look back at that in terms of assessing, is there some pattern of conduct that's occurring here? And that's consistent with, I believe, under 1203.4 and the other expungement statuses, law enforcement still has the ability to look at those prior convictions for purposes of making investigatory and other types of decisions.
Yes, I believe that's correct. And as a practical matter, I mean, in the other context, and I tell people this all the time, it really doesn't do much for you, other than, you know, it shows dismissal now, but the conviction and everything's still there. So if you go to apply for a job, or if you go to into an apartment or something like that, and they do a background check, I see this all the time. They'll say, it's there, you see it. And what you see, and I get this with nurses and doctors and things like that, is they may have had a DUI or they may have had some thing and they got a dismissal, and technically they're entitled to say, you know, in answer to the question, have you ever been convicted of a felony? No. And they do a background check, they see it existed there, and then they will get dinged because the agency will say, well, you weren't truthful with us because you did have a conviction, even though the legal answer is the correct one. So what we have to always tell people how to answer that question properly so they don't get dinged for being, you know, not truthful, but they are truthful in terms of what the law says their conviction is. So I don't know how this pops up, but that's just kind of a problem. I think the legislature needs to take a look at that.
I do think here, where it's wiped off the website, so if a person goes to the website and looks up the licensee, there won't be a disciplinary history. And we talked a lot about how any kind of discipline is kind of a scarlet letter for anybody to get clients or to have a practice or to move forward. So I actually do think that there are a great deal of practical benefits for lawyers to have this expunged and to move their life forward. Here, that may not exist in your cases, Mark.
You know, but that was, my initial question was, is that information available on the internet? Because if it's on the internet, you're not going to be able to wipe it off. You're not going to be able to do that. So as a practical matter, yeah, in terms of OCTC and so forth, it's quote unquote expunged, but as to the world, the internet world, it's not.
I just want to make one other comment, and Trustee Good had mentioned that, you know, restoring somebody's license, and to my knowledge, at least under the current definition, an expungement would not do that. So I just want to make that clear. The other thing I should point out is that I'm not aware of any other regulatory agency in California or attorney regulatory agency in the United States that has a similar process, but we may have faced different things than they have, so.
Thank you.
So I just want to jump in here. What you're being asked to do today is to weigh in on the proposed definition, which is here. And I think there are these outstanding issues. What is going to happen with the State Bar Court docket search? That's different than the attorney profile. Can OCTC use the expunged discipline history for purposes of identifying patterns of misconduct? The current proposal is no. Then next, moving on, if you go to the next slide, in implementation, there's two different options for implementation. One is the status quo, which requires a respondent to petition the Supreme Court. So regardless of what definition is adopted, there's a process issue. The second, it would be an automatic process if certain criteria are met, which would presumably include you haven't had any more complaints or no investigations, a whole host of criteria that would need to be established. So I think on the first question, what I'm hearing is there is a need to come back with greater specificity, perhaps it is, I think, in the written agenda item, but in the presentation, with what the definition and the impact of expungement is. I haven't heard the board weigh in on this second issue of implementation. So I think it would be helpful.
Trustee Tony, please.
Yeah, can we go back to the earlier slide? I have several comments. First of all, you can look at each of these proposals in isolation, and I can see how people who have worked on this say, okay, each one looks reasonable. I think when you look at it as a pattern and the three together, it looks like the state bar is more interested in protecting attorneys than the public. That is, so I want to say that very clearly, that this is part of my objection to these changes, to these proposals, all of them. The second thing is that there's an assumption. Let's talk about this concept of expungement that people have been talking about. So one of the areas that expungement is, used in has to do with minors, okay? Crimes committed when someone is a minor, okay? And the idea being that, gosh, now they're an adult, they've matured more, they were running with a bad crowd, they're now, trying to, make a life of themselves, and we don't want to, have a lifetime barrier for something they did when they were a kid, okay? Well, there aren't any minors that are attorneys, seriously, okay? So I don't, so that piece of it I don't feel is applicable. I also have a very different view that I am very much in support of expungement for the general public, but I am not for attorneys. Why? Because I think attorneys should be held up to a higher standard of behavior. I think there should be meaning to the term an officer of the court, okay? That there's an oath sworn when attorneys are sworn in. And that's very different from the general public. So yes, I think there should be a double standard. There should be a different standard. I want to be clear what my position is, that we should not be treating attorneys as though they were general public. They need to be held to a higher standard. So I think this is a mistake to go down the expungement route. Let's look at the various issues around the Farkas report, around discriminatory treatment for black male attorneys. I think this is the wrong approach.
Thank you. Can I ask for a little bit of elaboration on the second option with respect to an automatic expungement, or do we have a sense of the time periods that we're talking about and the conditions that would need to be met?
So that part is not well fleshed out either in the agenda item or obviously in the slides. I'd welcome input from Trustee Buenaventura and Trustee Good. They were two of the stakeholders that encouraged the adoption of another option here. But certainly it could be anything, as I mentioned before, the time period, and as Ms. Wilson mentioned, the time period, the lack of additional complaints or additional open investigations. As I mentioned earlier, we could limit it to the type of discipline, so certain disciplines would not be eligible. If you had, for example, an actual suspension longer than 90 days, for example, that you might not be eligible for the expungement. It would have to be less than that, something less than that. Those are some of the conditions that pop into my head, but I have not sketched out exactly what I think would be appropriate. Frankly, I'm open to guidance from the board.
Thank you.
So with respect to option one, the petitioning of the Supreme Court, in your experience, how long do you think a petition would take to the Supreme Court?
I don't know. I think that's part of the issue here is that I don't have a good understanding of how many have actually been made.
Okay.
What we learned about in the ad hoc commission was that we only know of two.
Yeah.
And I don't know whether there were more or not. I don't know how long they took to be acted on. I believe that both were denied. But the other issue that we were looking at here is keeping in mind the subsequent proposals about website removal and choosing to then define expungement broadly. We figured that it would make sense to, in some ways, make that, because the relief was so great, to make it, I don't want to say harder, but not automatic, if you will. But then, we came up with the option 2 as a result of feedback from the stakeholders.
So in that regard, trustees, does anybody have any feedback for Mr. Moad with that specific issue?
Good.
Brandon?
So Steve, do you think that modeling this system after the criminal justice system, where generally a person would have to be off for probation, now in California, generally misdemeanor probations are a year long, felony probations are 2 years long with exceptions, considering whatever crime they are convicted of. Do you think that there'd be value in modeling something after the criminal courts, or in kind of setting our own course? Kind of to Trustee Tony's point, which I'm definitely sympathetic to. We want to make sure the public is protected. Attorneys are held to a higher standard, but I think there is this desire to rehabilitate lawyers and to give them basically a carrot to chase after in order to reach that goal of rehabilitation. So I think any proposal would have to include that attorney being off of any sort of probationary terms. And, certainly, we're working on revamping the probation system to make it more evidence-based, to make sure that that licensees are receiving these sort of rehabilitative services tailored directly to how they committed their misconduct and their potential recidivism. So I would definitely want to see something tied to probationary terms, periods, successful completion, and then also payment of any sort of restitution that they're owed.
Go ahead, George, thank you.
I agree with that, but I think you also need to think about this in the context of the subsequent recommendation that's going to be discussed, which is removal from the web page. And from our point of view, given the broad definition of expungement, it would make sense to have the time limits for expungement be sometime after the time limit that we would be removing something from the web page. So for example, if the proposal is that something is not removed from the web page for 3 years or whatever, and I don't remember what the numbers are, for 3 years, because a judgment is made that the discipline is serious enough to warrant leaving it on the web page for 3 years, then clearly you shouldn't be getting expungement before that 3 years. So I think there's a tie between those two in terms of timeframes. And that also ties into the seriousness of the discipline, because the proposal for disbarment is that it stay on the web page indefinitely. So that would then mesh with things that get disbarment not being eligible for expungement.
Sarah, please go ahead.
I was going to say it just might be useful to move to the next
That's
slides
exactly
and
what I was
then
gonna
come
say.
back, because Trustee Stallings has mentioned recidivism and the time periods, and all of that is really important
Correct.
to what we're potentially going to be doing.
I do think the discussions are interrelated, so let's move on to profile page disciplinary history.
Great, thank you. So, like expungement, this discussion, this sort of the key issue and why we're here is to sort of balance potentially competing interests, at least potentially. And so the board directed staff to propose timelines for removal that are consistent with the practices of California regulatory agencies and other state attorney licensing agencies. So we have option 1, which was discussed at length in the ad hoc, and that is sort of aligning with the medical board, and that is public approvals are removed after 10 years and everything else remains posted indefinitely. And this policy is based on statute, and that is Business and Professions Code 2027. The next option is aligning with the nursing board, and this was also mentioned, although not as prevalently, during the ad hoc commission discussions. And that is public approvals are removed after 3 years, and disbarments, or their equivalent of disbarments, remain posted indefinitely. In our system, it would be that disbarment would remain indefinitely, and all other discipline, everything short of disbarment but above the public approval, would be removed after 10 years. So that's option 2. And option 3 is the development of an independent policy that is based on the state bar's data, where staff would develop proposed timelines based on a study of recidivism data, as you can see here. And the preliminary data shows that for new complaints moved to the investigation stage within OCTC, the recidivism rate increased by 25% during the first 5-year period, and only by 5% after that. And there's a similar pattern with the new complaints filed, except the curve flattens earlier. So, so that's kind of a summary of where this is. Additional issues that we would have to study include the extent that recidivism data is impacted by different levels of discipline. For example, somebody who's placed on probation with a stayed suspension may have a different recidivism rate than somebody who has placed on probation with an actual suspension, or depending on how long that suspension lasts. So here again, we are looking for direction from the board as to sort of the option to pursue.
Thank you, Mr. Moad. Trustee Sowell, please.
Can I just ask a question based on comments of Mr. Tony and also Mr. Stallings, which is they mentioned, sort of probation and sort of likening things akin to sort of the criminal justice system, so to speak. And what I haven't heard, unless I've missed it, is there a sort of a rehabilitative process? Is it for attorneys, not just, okay, you waited out this period of time, but I saw on another slide there were conditions, but I haven't heard anybody articulate what some of those conditions are. Is that on a case-by-case basis, or is there something that's currently in statute that would impose what those conditions are, as opposed to you just wait it out?
Yeah, I can answer that. It's not just waiting it out. So whenever the Supreme Court whenever the State Bar Court and the Supreme Court impose probation with a stayed suspension or with an actual suspension, that probation carries with it conditions, and those conditions can take a variety of forms, typically tied to the nature of the underlying conduct, with some kind of standard conditions. There's normally a condition, you have to do some educational programs, either ethics school, client trust account school, something along those lines. Typically, you have to file reports with the probation officer at periodic times to report on various issues. And then there may be other conditions like payment of restitution, payment of all the costs, et cetera, that have to be complied with during the probation. And so it is kind of supposed to be a rehabilitative period in which attorneys demonstrate through their compliance with the probation conditions that they have addressed ideally some of the underlying causes of the misconduct to the extent those can be identified. Does that?
And I think if you're asking with respect to both the expungement and then this is website removal, and what is outlined in the agenda item is the distinction between website removal and expungement, right? This is short of expungement because it's still a public record. There would be criteria. So if you keep getting disciplined, things are not going to be coming off the website, right? So it's not just we wait it out. And based on, just depending on which option the board selects, then staff could come back with a fully articulated proposal with those criteria outlined.
Do we have any sense of, like, the metrics around this? How many attorneys are sort of in this process or maybe seeking you know, the remedies that would allow them to return to the profession on an annual basis?
I'm not sure, if you mean disbarred attorneys wanting to be reinstated, that's a very low number. If you mean the number of attorneys, I mean, it depends on what the board decided, but if this was adopted and it went into effect, period, like not prospectively, but just period, presumably attorneys who were disciplined 20, 30 years ago could be eligible, and that's thousands of attorneys, right? Because right now, any discipline you get stays on your profile page in perpetuity, unless it's been expunged, which, as we said, we only found instances of 2 petitions for that being filed.
Anyone else? So I will just note that the last column here relates to the commission's recommendations, and I could be wrong, but I believe that this is the only place where we see the commission's recommendations so explicitly set forth in the recommendations. And is that because the commission was very clear on this? I recall some of the discussions, because I was on that commission as well. I recall some of those discussions, in which case I'm just wondering why, well, no, I know why it's all here. I take that back. Sarah, please go ahead.
Yes, the commission was very clear about those timelines, and in point of fact, trustee Buenaventura and myself thoroughly endorsed those timelines.
Yes.
I know OCTC does not. So that's certainly an option here. I mean, what I will say vis-a-vis the medical board option, removing something after 10 years, the damage has been done. I mean, it's been 10 years of an effect upon somebody's life. I'm not sure how they're going to be rehabilitated at that point. And I think the commission's recommendations, and note, disbarment never comes off, I think permit rehabilitation with good conduct and meeting all of the other requisites. So, you know, that's kind of where we're at.
So I will just say that we focused on options other than the commission's options because we deemed the board's directive to develop a proposal that was more consistent with the other state regulatory agencies and attorney licensing agencies in other jurisdictions as at least an implicit rejection of the commission's work. That said, of course, the board can do whatever it chooses today, including resuscitating the commission's proposal.
Well, and just to remind folks, we're not asking the board to take any official action today. I mean, we're giving feedback, asking questions, providing some guidance for when this comes officially to the board. Trustee Tony, you indicated you wanted to speak.
I think it'd be useful for the staff when this comes back to have some data on Arnie's question about how many attorneys would be impacted by this. I think that's a useful data point, so I appreciate you asking that. And, you know, I will bring this up again, but I just want to remind people that this ad hoc commission had an incredible bias in its construction, and that is that it was a commission that had 4 attorneys who were on the board of directors, the board of trustees served on that ad hoc committee, plus something like 18 out of the 20 were attorneys. And so that's an incredibly biased group to make these kind of recommendations, and it's part of why I do not accept the validity of these recommendations.
I mean, so let me, if I can.
Please.
Let me just say, having been a member of this ad hoc commission, which this board asked this ad hoc commission be formed. So we were charged with exactly what the board wanted us to do, which was to come up with fairness and a process to address some of the disparate treatment of African-American attorneys and the effects of that kind of um, um, unfairness. When we had discussions, for example, about expungements, it wasn't easy. There, even though almost everybody there was an attorney, there were a lot of people who had different viewpoints. And at some point, I can remember several occasions, I had to bring it back because the argument was, we're protecting attorneys, right? So I got that. But I found it necessary to bring it back and say, hey, our focus was supposed to be on how do we address the disparate treatment of African-American attorneys? How do we change a system that has been broken, that has been unfair to attorneys of the past? And so there was a vigorous debate, and coming up with these recommendations was not easy, because even though there were more attorneys there and not members of the public, that side of the debate that you were concerned about was well vetted and well covered. So it wasn't easy, but I think we came up with a plan that spoke to fairness and addressed the issues this board wanted us to address.
And I appreciate that. Just for the record, the board voted to establish this committee November 2020, which was right before I was appointed. If I were part of that discussion, I would have argued a different approach to addressing the findings in the Farkas report. I believe this is absolutely the wrong approach and results in greater harm to the public.
Trustee Stallings?
I would just echo what Ray talked about as far as vigorous discussions, and also point out that we had subject matter experts from other areas of California, including the medical board, other licensing agencies, like the Attorney General, and we had experts from out of state that really provided, I thought, a rich diversity of opinions. And I'm really proud of the work of the ad hoc commission, and I think that all viewpoints were really presented well and artfully just articulated and considered. So I came out of the ad hoc commission having my mind changed about a few things. I kind of came in with a certain predilection, and I think the discussion really did sway. So I'm happy with the work product. Understand that individuals who were not here when the ad hoc commission was formed might have differing opinions, but as someone who sat through a majority of the meetings, I concur with the words of Trustees Good and Buenaventura as to the work. Just getting back to the timeline issue, if we ask for further study as to maybe all three options, or to address what Trustee Sowell brought up as far as the actual numbers, is that sufficient direction, or would you like us to pare it down even more?
I think George moves the microphone over.
I think it's fine, because I think I'm also feeling like this is just an overwhelming amount of information. We're not even done. So I also think when we bring this back, we need to chunk it up into topics like cost, one meeting, another meeting, all this issue of public records. So I think we can certainly work these up further.
And quite frankly, it makes sense given the expansive breadth of the commission's work, right? And the many, many meetings that folks went through. And a reminder, right, the two foci were fairness and effectiveness of our discipline system, right? And all of the work that went into thoroughly examining those two key components of the state bar's current system and our past system that had identified clear flaws in it that had adverse impacts on attorneys of color. All of those issues were very serious. Leah just mentioned I think we're halfway through the subtopics on this item, and given that halfway point and looking at the clock, it's 5 until 5. I don't know if staff has a sense of how much more we wanted to get done today, but I do want to check in on just timing. It's been a very full day, in some sense for me at least, but I know there's still a lot more work on the agenda to be done.
Yeah, I think we should not go any later today than 5:15. That would be the latest, and that would be 20 minutes. I am, just given the nature of the conversation thus far, I'm not sure. Like, the next topic we have is similar, but it's for dealing with criminal conviction history. I'm just not sure that it would be useful to continue today. However, we do need to get through it and get some feedback. So it's really the will of the board. 20 minutes is the max I would allot, and we should endeavor to finish this item within that 20 minutes, regardless.
I mean, I think because it really fits with what we've been talking about, continue on, if we can get through it, great.
All right.
Okay. Any last input on this last issue, on the issue we just talked about with removal of the disciplinary history? Okay, let's move on to profile page criminal conviction history.
Thank you. This is very similar as was stated. The reasons that we're here are the same. We're looking at balancing competing interests, and we're looking for potentially input from the board, or at least updating the board on where we are right now. And that is option one. Again, we are looking at potentially aligning with the medical board, again, per statute, Business and Professions Code 2027. Upon receipt of a certified copy of an order granting relief pursuant to 1203.4 or a similar statute of the Penal Code, the medical board posts a notice that the relief was granted next to the posting of the conviction, of the notice of conviction, and the date of that order on their website, and all records remain posted. So this option would include removal of conviction-related discipline, consistent with the board policy to remove other discipline that we just talked about. If, for example, the board adopts something that says discipline comes down after, X period of days or years, then that would come down, and presumably the notice, if it was posted prior to, would also come down. So option two is to remove the transmittal. And upon receipt of an order granting relief pursuant to section 1203.4, the transmittal itself, which is the initiating document in a criminal conviction matter, would be removed, but any discipline resulting from the criminal conviction would remain posted until the timeframes for removal from the website, whatever those timeframes are that are established by the board. And that means that discipline resulting from criminal convictions would not be removed any earlier than any other discipline, which is certainly possible under option one, right? So it may be that the option one, a criminal conviction matter might be removed within 6 months or a year of that conviction, and right after that 1203.4 is granted, but a discipline for something else may stay up on the profile page even longer, something that didn't result in a criminal conviction. Option three is to remove the transmittal and the discipline upon receipt of an order under 1203.4. And this option will result in discipline, again, based on criminal convictions being removed significantly faster than the timeframes. When I said earlier option one, I meant option three. Option one, it would stay up there, would just have the notation. Option three, that discipline would come down significantly faster than discipline that is not based on a criminal conviction. So again, as I mentioned, we're looking for some direction for the board, or at least to inform the board of where we are at this point. There is some concern about removing discipline that where the conviction is still a valid basis of of discipline. And in fact, the statutes governing criminal convictions specifically state that relief under 1203.4 has no impact on whether that conviction can then be disciplined by the state bar. That is consistent with the medical board. They have other statutes that say the exact same thing. And again, as we have talked about earlier, and so I won't belabor it greatly, but relief under 1203.4 is not an expungement in the truest extent of the word. It's not a finding of factual innocence. It's not a designation the person has been rehabilitated. It's not a grant of a pardon or a commutation of a sentence. It doesn't even result in sealing of the record. The only real relief that's granted is that they can say that they were not convicted when they apply to a job at a private employer. And so, and as I mentioned, with the Ban the Box and the Fair Chance Act, that, that may not be so significant anymore. But that's kind of where we are. It is still a basis for discipline, and it conceivably, depending on the timing of it, and one of the reasons that we suggested that the discipline not come down until or the transmittal not come down until the discipline is imposed, is that may be confusing to have an ongoing discipline case where there is no notation on the profile page, et cetera.
George, please.
Just briefly, my understanding of option 2 is that essentially it would be a slight variation on how we treat notices of disciplinary charges and discipline. In other words, currently when we transmit the criminal conviction, it goes on to their webpage profile to notify the public that this person is facing a disciplinary proceeding based on a criminal conviction. That would remain up until either we got discipline, and then if we did get discipline and it was expunged, we would then remove the notice of transmittal, but the notice of discipline would then stay up for whatever period of time the board decides discipline should stay up. That's consistent with the fact that we can pursue discipline even if something is expunged. So even if a conviction is expunged, we can pursue discipline. That discipline is an independent action from the criminal conviction itself. And so it makes sense in option 2 to leave the discipline up for whatever time period the board decides is appropriate, even if that conviction has been expunged in the interim. Option 3, from our point of view, doesn't make sense because it's basically removing from the public notice of discipline validly imposed, even though the conviction underlying that discipline has been expunged.
And am I correct to remember that the distinction there is going to be where the convictions involve crimes of moral turpitude? Is that where that comes into play?
No, not.
No.
I mean, all of our, for non-felony convictions, we transmit if we believe the facts or circumstances of the crime either involve may either involve moral turpitude or may involve other misconduct warranting discipline, which are the 2 standards on which we transmit. So it would apply to all those sets of crimes. And felonies are in a different situation because felonies typically require discipline.
Okay, thank you for the clarification. Trustees, any questions, comments, direction? Trustee Stallings, please.
I think just option 2 makes the most sense given the presentation. That's kind of where I sit.
Thank you. Anyone else?
Just curious, could you begin some disciplinary proceedings against someone who simply had been charged with a crime?
The answer is
I
yes.
hate to raise
No,
that
the
issue.
answer is yes, but that would be based on the conduct. In other words, we have 2 types of proceedings. We can proceed under certain statutes where there's a criminal conviction, and then the criminal conviction serves to establish the facts of the conviction, and the issue for the court is just whether or not having the facts of that conviction established, in certain instances, the circumstances surrounding that crime nevertheless warrant discipline, even if it's not one that involves moral turpitude. We always have the option, however, so say, for example, someone today goes out and commits a massive fraud. And the district attorney's office is still trying to decide whether to proceed, but we have independent evidence on which we can proceed on that fraud. We could still file an ordinary disciplinary proceeding based on the underlying conduct, with us then having the burden of establishing that conduct by clear and convincing evidence. We wouldn't have a criminal conviction to rely on as establishing the elements of the conviction. Does that answer your, okay.
Sarah, please.
Just with respect to option 2, I note that the discipline would just be removed based upon whatever it is we decide we want to do on the other stuff. So, so I guess I'm okay with that. So.
Okay. If there's nothing further on this, let's move to the pre-transmittal ENEC. And for some reason, I thought that this was given a different moniker in the body of the staff report, that we were going to move away from ENEC to some other characterization.
So yes, they are, so that's one of the proposals with respect to ENECs, is to change the name of ENECs to pre-filing settlement conferences. So if you were to adopt that one, then what we would be talking about is having a pre-filing or a pre-transmittal settlement conference for misdemeanor convictions. So importantly, first off, this only applies to misdemeanor criminal convictions. And the issue is whether the board wants us to pursue development of a pre-transmittal settlement conference for misdemeanor convictions. So to understand that, as I just mentioned, we transmit, when we get certified copies of a conviction, we are under a statutory obligation to transmit to the review department within 30 days any conviction that we believe involves or may involve moral turpitude or other misconduct warranting discipline. So we have to think about this in the context of that 30-day mandatory transmittal time period. In other words, that's what the legislature said, and earlier the board decided not to adopt the recommendation to seek a statutory amendment to extend that time. So we're operating in that 30-day time period. That's important because it raises practicality concerns that the State Bar has noted, State Bar Court has noted, in terms of being able to regularly schedule these types of conferences within that limited period of time, the time from when we get the certified records, provide notice to respondent, have the respondent request, join in a request for a settlement conference, and then try and get that settlement conference scheduled so that it can be completed before those 30 days are up for us to file. That poses immense practical concerns. That said, we have proposed two options, which are basically referred to as the OCTC may and OCTC must. In other words, there's two options here. We could either make it optional. OCTC could look at the convictions, and if OCTC made a determination that they believed a pre-transmittal conference could in fact resolve issues or assist in determining whether or not it did in fact involve moral turpitude or other facts warranting discipline, or whether there was a likely potential for settlement before transmittal, OCTC could request it. The second one would be mandatory. In other words, within some period of time after we receive the certified records, we would be obligated to notify the respondent of a pre-transmittal settlement conference and start the machinery going and conduct it. In the second one, under the must, if we did not pursue that, we would not be allowed to transmit until we had taken steps to do this. In either option, there would have to be provisions that would say if the court is unable to schedule this within the 30 days, or it can't be held for whatever reason, OCTC then is free to transmit without the settlement conference having been conducted, so that we can comply with the statutory requirement that we transmit within 30 days. So those are the two options, an optional one or a mandatory one. ADDC, the Association of Disciplinary Defense Counsel, is in favor of pre-transmittal conferences. They strongly express a preference for option 2, the mandatory one. The State Bar Court is in favor of pre-transmittal conferences, but they expressed several concerns, including The practical one, that it's not really realistic to expect the parties in the court to regularly be able to hold a pre-transmittal meeting within 30 days, and trying to do so may put unnecessary stress on the parties in the courts. Two, even if the conference could be held within 30 days, the parties would find it difficult to complete the stipulation in the remaining time, which could create a disincentive for us to enter into stipulations. I will just say, in terms of that concern, if in fact we believe that a stipulation was likely, we would do just as we do now, which is if we've had conversations with the other side and believe that a settlement is likely, we on some occasions do in fact hold back and not transmit in violation of statute, knowing that we're likely to reach a settlement that will save everybody time and basically accomplish the purposes of the transmittal in the first place. And three, if pre-trial transmittings are optional, as in option one, OCTC will rarely, if ever, request a pre-transmittal conference. I will say, we obviously, if the board directs us, we would be inclined to request those where we believe there is something that could be accomplished. It will, however, undoubtedly be in fewer instances than if we are required to do it on every single transmittal. So those are the options, and that's the input we're looking for. And with that, I will throw it over with 5 minutes left.
Thank you for that. Any questions, input? Anybody? Sarah, please. Trustee Good.
Mr. Cardona, is there any way that we can extend the time period so that, your office doesn't experience this time crunch?
This was addressed kind of previously, but absent a statutory amendment, it's a statutory directive. Once we get the certified record of conviction, which is basically when we know what the person has been convicted of, we then have that 30 days to transmit. Absent a statutory amendment to change that, we're operating under that requirement.
And I believe that the ad hoc commission, did they not recommend extending that 30 days, but the board did not approve that? Or the commission itself voted that recommendation down? I think we've already addressed this question of why the 30-day, that we're not seeking the 30-day extension, to extend the 30 days.
In 2019, it used to be 5 days. And that was an impossible task. And so in 2019, we sought a statutory change to change it to a reasonable time. And the most that we could get was the 30 days. So I don't anticipate that the legislature would be willing to extend that beyond the 30 days that they gave us in 2019. And I think that's the reason that wasn't carried forward as a proposal, but I could be wrong.
It actually was carried forward as a proposal, and at the January 2023 board meeting, the board elected not to proceed with that, I think, based on these concerns.
Okay. Trustee Sewell.
I know we're getting close to time here. I just had a question about cost in light of some of the budgetary considerations that we've been talking about, and that is, I know in the item itself, for each one of the various sections, there was some fiscal analysis that was done. But is there a sense of what some of these changes in their entirety, what the price tag might be in their entirety?
For this particular one, or for all of them?
Yeah, all of them together. What's the big hit here?
No, only as specified in the items. For example, the last one we're going to get to in 2 minutes, which I'm going to cover, that has a proposed price tag of $250,000. If there are changes to the discipline cost model, as we said, the maximum change in the costs assessed would be $350,000, but our collections against assessed costs is very low. So, we would be looking at about 5 to 10% of the $350,000 is the actual fiscal impact. So for many of these that are process changes, I'm not sure what, if anything, this particular change would cost. The website removal, there'd be like one-time costs, certainly with IT to effectuate that. And then going forward, if there's all of a sudden a huge increase in people contacting us, asking us for information, that currently is on the attorney profile page. That would presumably have a cost, but it's really difficult to articulate, and I think most of these do not have a significant cost, is the bottom line. The ones that do, we've tried to call it out. It sounds like there's not a lot of
Yeah.
board direction on must versus may, so I would
Yeah,
suggest,
please.
George, you go forward as you wish, which is the may.
The may.
Okay, and I will, in 1 minute, try to cover the last, if you could go ahead, Tinny. So this one, when we talk about the Farkas report and recommendations, the subsequent recommendations, remediation recommendations identified by Professor Robertson, I want to clarify that a number of these ad hoc commission recommendations do tie directly to Professor Robertson's recommendation, but most especially this one, because in the Farkas study, there was a very high correlation between lack of representation in disciplinary proceedings and disciplinary outcomes, and there are racial disparities in who is represented in state bar disciplinary proceedings. So one of the recommendations was that the state bar develop an appointed counsel program. And so we have done that. So the model that has been proposed looks like what exists in many courts. For those of you familiar with court-appointed panel models, there we would recommend that the state bar establish kind of an independent administrator for an appointed counsel program. Importantly, we already do, the state bar court already does appoint counsel in very limited cases, and the existing program would be absorbed in this broader appointed counsel program under the paradigm that staff has developed. The hourly rate, it's a proposal that this model would reflect an hourly rate of $300 an hour. That is the hourly rate paid to current state bar appointed counsel. And the budget would be up to $250,000 for a pilot. Attorneys would be eligible based on their income, and the income determination would be based on whether or not they are eligible for fee waivers for licensing fees. And I believe that the income cap on that is $67,000 a year, Steve, or $75,000 to be eligible for a fee waiver. So we're talking about fairly low-income attorneys. A $250,000 cap, we are not going to serve that many in a pilot. But this is the model that staff proposes, and it's more fleshed out in the agenda item. We are not bringing it forward for a vote for obvious reasons, and that is the fiscal implication. Even though, as I said, this is an area that was very directly called out, both in Farkas and Robertson, we know it will impact our, it should have a meaningful impact on our disciplinary outcomes. Given the state bar's financial position, we are just bringing this forward for information and simply saying, if at the point the board decides it wants to fund a pilot program, this is the design that we would recommend.
Thank you, Leah. Any questions for Leah on that last point? All right. We are adjourned for the evening. Reconvene tomorrow morning at 9:30. See you then. Thanks, everyone.